He was perfect. The kind of man every parent hopes their daughter will marry. Successful. Charming. Generous. At their wedding, he promised me he'd protect her with his life. 5 years later, I'm holding her in a police holding cell, her face swollen, her ribs broken, and he's telling the cops she attacked him. The worst part? They believed him. Because he called 911 first. Because he was smiling. Because no one wanted to see what was really happening behind closed doors. Welcome to the She Defied Age channel. Before we continue, please let us know in the comments section which region you are connecting from. We genuinely value this information. We wish you a deeply engaging experience with this remarkable narrative that is about to unfold. Chapter 1. The Fracture. The telephone's shriek cut through the Vancouver darkness like a blade through silk. 3:47 in the morning according to the bedside clock, its digits glowing accusingly in the black. I had been asleep for perhaps 90 minutes, the kind of fractured rest that comes with age and the weight of a mind that never fully powers down. Outside, the Pacific wind howled through the Douglas firs surrounding my Shaughnessy estate, and the rain, relentless biblical rain, drummed against the slate roof with an intensity that seemed almost personal. My hand moved to the phone with an automaticity born from decades of midnight emergencies, though those had theoretically ended when I retired from the provincial appellate court 3 years prior. I had spent 42 years reading the law, interpreting statutes, reviewing cases where lives hung suspended between interpretation and precedent. The calls that came at this hour during my active tenure rarely brought news of celebrations or promotions. They brought only the sound of human catastrophe, the acoustic signature of systems failing and lives unraveling. The voice on the other end was not immediately recognizable. There was a quality to it that bypassed my conscious understanding and went straight to the ancient part of my brain that knows danger. It was a sound like someone speaking underwater, or through pain, or through fear so complete it had overridden the normal filters that shape human speech. I had heard this sound before, many times, in the testimonies of victims who sat in the witness box across from judges who may or may not have believed them. Mom. The single word was a confession and a plea simultaneously. It was my daughter Rebecca, though the voice was so transformed by distress that for a moment my mind refused to accept the identification. My fingers gripped the phone tighter. "Where are you?" I asked, my judicial training immediately suppressing the panic that wanted to flood through my system. Protocol first. Information second. Feeling not at all. "I'm at the downtown police station," she said. The words tumbled out in a rush of incoherence. "He said I did it. He said I tried to kill him. They arrested me, Mom. They actually arrested me. They think I'm the one who—" "Slow down," I commanded, using the same tone I had employed for 4 decades to restore order to courtrooms where emotion threatened to overwhelm procedure. "Tell me exactly what happened." The narrative that emerged was fragmented, interrupted by what sounded like suppressed sobs. My son-in-law, Marcus, had come home from an evening event highly intoxicated. There had been an argument, the details were unclear, but something about Rebecca's appearance, her conduct, her alleged betrayal. Marcus had become aggressive. Rebecca had fled to the kitchen. There was a knife. There was a struggle over the knife. Marcus had sustained a cut, a significant one across his forearm. He had called emergency services and told them that his wife had attacked him with intent to cause serious injury. "And the police believed him," Rebecca whispered. "There's a detective here, Detective Sarah Walsh. She keeps looking at me like I'm a criminal. She won't let me call you. She said I should wait for a lawyer. But Mom, I didn't do this. He did this to himself." I was out of bed before she finished the sentence, my body moving with an efficiency that seemed to bypass conscious decision-making. The bedroom was dark, the furniture rendered into abstract shapes by the minimal light penetrating the heavy curtains. I found my clothing by touch and memory, muscle memory that had atrophied but not disappeared over the years of retirement. My mind was already running ahead of my actions, calculating time, consequences, procedural requirements. "Don't tell them anything else," I said into the phone. "Don't answer questions. Don't sign anything. I will be there within the hour. And Rebecca, speak to no one about this without counsel present. Do you understand?" I understood. she said, the gratitude and fear mixed equally in those 3 words. I ended the call and finished dressing in the darkness. My husband Richard remained asleep, undisturbed by the phone's brief intrusion. He was a man of extraordinary equanimity, a retired cardiologist who had learned long ago that my life did not run on conventional schedules. I left him a note on the kitchen counter, an old habit, and moved toward the garage. The Mercedes responded to the ignition key with its customary low growl, and I pulled out into the rain-drenched street with a precision that had not diminished with age. Vancouver at this hour was a different city from the daytime version. The streets emptied of their commercial bustle. They became something else, something that revealed the city's true nature. The rain fell in sheets, and the traffic signals cycled through their program changes for no one. I ran 3 of them, a conscious choice and a conscious rule-breaking. The laws I had spent 42 years upholding were suddenly obstacles rather than frameworks. The drive downtown took 19 minutes. I knew the route like an anatomist knows the circulatory system. I had driven it countless times for hearings, for trials, for the machinery of justice that had consumed the bulk of my adult life. But this drive felt different. I was not driving toward the law. I was driving against it or beside it or beyond it. I was driving toward something more primal than precedent. The police station occupied a brutalist structure of gray concrete and small windows, all harsh angles, and the architectural language of institutional power. I pulled into the loading zone and walked toward the entrance with the same measured gait I had used walking into courtrooms for 4 decades. The habits of authority do not simply dissolve. They become part of the body's vocabulary. The front desk was staffed by a young uniformed officer, his face betraying the particular exhaustion that comes from overnight duty. He was perhaps 27, with the earnest expression of someone still trying to prove his commitment to something he only partially understood. Behind him, the station proper hummed with the low-level activity of nighttime police work, radio chatter, the sound of footsteps on linoleum, the ambient despair that hangs in every holding facility from Vancouver to Sydney. I need to speak with Detective Sarah Walsh, I said, my voice not elevated, but carrying the weight of someone accustomed to being obeyed. Regarding the arrest of Rebecca Chen. The officer's eyes flickered with something, recognition perhaps, or the beginning of it. Ma'am, he said, the protocol is that you'll need to speak with the duty sergeant. The custody matters. I am Justice Margaret Ashford, I interrupted. I have not been referred to as ma'am in 42 years, and I do not intend to begin now. My daughter is in custody. You will tell Detective Walsh that I am here, or you will have me arrested for obstruction as well. Your choice. The officer's face cycled through several expressions: annoyance, confusion, and finally recognition of a situation spiraling beyond his authority to manage. He picked up a phone and dialed an extension. Within 5 minutes, Detective Sarah Walsh emerged from the secure corridor. She was a woman of perhaps 50, with the weathered appearance of someone who had spent decades looking at human beings at their worst moments and had not entirely recovered from the accumulation of that knowledge. Justice Ashford, she said, and there was neither warmth nor particular coolness in the greeting. It was professional, measured. I received the message you were here. My daughter, I said. I want to see her. I want a full report of the allegations and the evidence. And I want to know why she was arrested without representation present. Walsh glanced at the young officer, then back at me. If you'd like to come this way. The holding cells occupied the basement level of the building, accessed through a series of security doors that buzzed open with the sound of institutional machinery. The hallway was painted institutional green, a color that seemed designed specifically to drain hope from everyone who walked down it. The fluorescent lights hummed with an electrical frequency that existed just at the edge of human perception, making one's teeth ache without quite consciously registering why. Rebecca was in one of the small interview rooms, sitting at a metal table. The first thing I saw was the discoloration around her left eye, swollen purple, the bruising still actively darkening. Her lip was split, the blood dried to a rust-brown color. Her clothing was torn along one shoulder, the expensive blouse she had likely been wearing for the evening event now reduced to tatters. When she saw me, something in her face broke open. It was the expression of a child who had been lost and suddenly recognized a landmark that meant safety. She stood up to move toward me, and I saw the way she held her ribs, the protective way she moved that suggested fractures or significant bruising beneath the clothing. I took her in my arms, and she collapsed against me with the weight of everything she had been holding together alone. There, I murmured, using the meaningless comfort words that parents use when words have no meaning. I've got you. She pulled back, wincing, and began to speak in a rush. He came home angry, she said. He was drinking. He started saying things, that I had disrespected him, that I had humiliated him at the dinner. He grabbed my arm, really grabbed it, and I tried to pull away. He hit me. I put my hands up and he kept hitting me, and I ran to the kitchen and I grabbed a knife just to keep him away, just to create space between us. She lifted her sleeve, and I saw the tapestry of violence written on her forearm. There were fresh bruises, purple and angry, but beneath them were older ones, yellow-green, the fading browns of healing damage. Near her elbow were 3 small circular burns, marks that I recognized immediately as cigarette burns. They were too perfectly formed, too deliberate, to be anything else. How long? I asked quietly, though I was not certain I wanted to know the answer. Rebecca looked down at her arm as though seeing it for the first time. Almost 2 years, she whispered. My daughter had been suffering abuse for nearly 2 years, and I had not known. I, who had spent 42 years reading the signs of violence in the testimony of victims, had missed the signs in my own child. The realization was not a surprise. It was a confirmation of something I had suspected about myself for some time. That all the reading of law and all the years of judicial training had not made me wise. It had only made me blind in a particularly specialized way. We need to document everything, I said, standing up. Every bruise, every burn, every old injury, and I need to see the evidence they're claiming supports their case. When I emerged from the holding cell, Detective Walsh was waiting in the corridor. The cut he sustained is consistent with his account, Walsh said without preamble. Clean laceration across the forearm, defensive in nature, suggesting he was warding off an attack. There's a witness, a neighbor who heard the altercation and called in the complaint. He corroborates Mr. Chen's version of events. Did this witness see the attack occur? I asked. No, Walsh admitted. He heard raised voices and then heard your daughter-in-law threatening Mr. Chen with a knife. He called 911. And Mr. Chen made the initial call, I said. Correct, Walsh confirmed. Called it in himself. Said his wife had attacked him, and he was concerned for his safety. When we arrived, we found him with the injury and your daughter in an agitated state. Did anyone conduct a forensic examination of my daughter? I asked. Photographs of her injuries. Documentation of the defensive wounds on her hands. A medical examination to assess the extent of her injuries? Walsh's expression shifted slightly. She's in custody. Protocol calls for us to gather evidence from the victim. Mr. Chen is not the victim, I said, my voice taking on the particular edge it had developed over 4 decades of judicial authority. My daughter is the victim. She was attacked, she defended herself, and now she's in custody because the first person to call 911 controls the narrative in the mind of law enforcement. It's a tactic as old as violence itself. I want a forensic examiner brought in here immediately, I continued. I want every injury documented. I want her blood work analyzed to see if there are substances in her system that would account for the alleged aggression. I want Mr. Chen's history reviewed, prior incidents, prior complaints, prior litigation. And I want to speak with Captain Rodriguez. Now. Walsh stared at me for a moment, and I saw the calculation happening behind her eyes. She was assessing the risk I represented. She had seen my name in the newspapers after my retirement, had heard the stories about the judge who had built a reputation for irreverence toward prosecutorial overreach and police department procedures that cut corners. She was evaluating whether pushing back against me was worth the professional consequence. The captain is in his office, she said finally. But Justice Ashford, I want to make clear that we're conducting this investigation properly. We're following protocol. Protocol, I said, is often just another word for habit. And habits are easier to change than justice is to achieve. Captain Rodriguez's office was on the 3rd floor, A space that somehow managed to be both imposing and depressing in equal measure. Rodriguez himself was a man in his late 50s, with the bearing of someone who had risen through departmental ranks through a combination of competence and the ability to not offend powerful people. He stood when I entered, and there was genuine anxiety in the gesture. "Justice Ashford," he said, extending his hand. "This is quite a situation." I did not take his hand. "Sit," I said. "I want to understand how my daughter came to be in a holding cell, while the man who assaulted her remains free." Rodriguez sat, his discomfort evident. "According to the evidence we have, Mr. Chun called 911. He had a visible injury. He provided a coherent account of the incident. Your daughter had defensive wounds," I interrupted. "Had bruising consistent with multiple blows. Had evidence of long-term physical abuse. Had a story that is demonstrably true, which is that she was attacked and defended herself. Yet somehow, in your assessment of these facts, she is the perpetrator." "We followed the evidence," Rodriguez said, his voice taking on a defensive tone. "You followed the evidence of a man with the resources to manage his appearance and his narrative," I corrected. "You did not follow the evidence of my daughter's body. And you did not do the investigative work necessary to understand the context of this incident, which is 2 years of systematic abuse." Rodriguez's face darkened. "Justice Ashford, I understand you're upset, but we can't just—" "I can and I will," I said. "I am requesting that you conduct a full and thorough investigation into Mr. Marcus Chun, including any prior incidents of domestic violence or allegations. I am requesting that all forensic evidence be collected and properly documented. And I am requesting that my daughter be released on her own recognizance while this investigation proceeds. Failing that, I will file a complaint with the Provincial Oversight Board, and I will make it my personal mission to ensure that this department receives the precise level of scrutiny that it deserves. Do we understand each other, Captain?" The silence that followed was the particular silence of a man confronting professional consequences he had not anticipated. Rodriguez looked at me, then away, then back again. He picked up his phone and dialed an extension. "Get a forensic examiner down here," he said into the receiver. "We're conducting a full examination of the female subject in the domestic violence case. And pull all files on Marcus Chun, criminal history, civil litigation, anything filed in the last 5 years. Now." When he hung up, he looked at me with something that might have been respect or might have been resentment. I couldn't determine which, and at that moment I didn't particularly care. Chapter 2: The Reckoning. The forensic examination took 3 hours. I sat in the observation area watching as a thorough documentation was conducted of every injury on Rebecca's body. The marks that had been visible were recorded in careful detail with photographs, measurements, and clinical notation. But it was what became visible during the examination that told the fuller story. The bruising on her torso was extensive, wrapping around her ribs in patterns that suggested repeated impacts. The burns, there were 7 of them, not 3, were arranged in what appeared to be deliberate clusters. The defensive wounds on her hands were older, some of them weeks old, suggesting a pattern of violence extending back much further than the incident of the previous evening. By the time the forensic examiner finished, the clinical evidence was unambiguous. This was not a case of mutual domestic violence or a conflict between 2 equals. This was a case of systematic, escalating abuse carried out by someone with the physical power and the willingness to inflict it. During this time, the investigation into Marcus Chun was proceeding in parallel. Detective Walsh appeared in the observation room where I was sitting with Rebecca, who had been brought in to be present during the results of the examination. "We found something," Walsh said, her tone indicating that what she had found was not what she had expected to find. In 2018, Chun was investigated by police for assault on a girlfriend. The girlfriend, a woman named Jennifer Park, dropped the charges. We also found a civil lawsuit filed in 2020 by another woman, Sarah Duchamp, alleging physical assault and emotional abuse. That case was settled out of court with a non-disclosure agreement. "Non-disclosure," I said. "Which means you cannot comment on it, and the financial incentive to silence creates exactly the environment where predators thrive." "That's one interpretation," Walsh said. But it complicates the picture significantly. There's also a restraining order filed against him in 2023 by a woman named Alexandra Holmes. It was never served because the address listed for him was his apartment in the West End, and he claimed he no longer lived there. The case lapsed. So you have multiple reports of violence, systematic abuse, and deliberate evasion of legal process, I said. And you had my daughter in custody because she did not successfully allow herself to be seriously injured without fighting back. Walsh held my gaze. I made a call that was wrong. I should have looked deeper. I should have asked better questions. The admission was not comfortable for her to make, but it was there, hanging in the air between us. In that moment, Walsh transformed in my assessment from a police officer doing her job to something more complicated. A person who was willing to see that the system within which she operated was sometimes working against justice rather than for it. Captain Rodriguez appeared, his expression indicating that he too had been reviewing the case file with fresh eyes. "Justice Ashford," he said, "we're releasing your daughter. Immediately. Effective now, Marcus Chun is being brought in for further questioning regarding all of these prior allegations." "And the charge against my daughter?" I asked. "Being dropped. There's no basis for it." Rebecca made a sound that was something between a sob and a laugh, the release of tension that had been sustained for too long. She stood and held onto my arm, and we walked out of the police station into the gray Vancouver dawn. The rain had stopped, though the streets were still wet and the sky remained heavy with cloud. The city was beginning its transition from night to day, from the vulnerable hours of darkness to the exposure of daylight. In the car, Rebecca began to shake. It was not the shaking of cold, but the shaking of adrenaline departing, of systems that had been in acute survival mode beginning to release. I drove to the Pacific Medical Center, where a colleague from my years on the bench still worked as a trauma physician. I wanted a medical assessment that was separate from the police investigation, a baseline of her injuries that would exist independent of the criminal justice process. Dr. Patricia Sue examined Rebecca with the careful thoroughness of a physician who understood the forensic and therapeutic implications of her work. By the time she finished, the clinical picture was even more precise. Rebecca had 2 broken ribs, a fractured wrist that had been improperly healed at some earlier point, damage to the inner ear suggesting repeated strikes to the head, and what Sue described as injuries consistent with being struck by an object, possibly a lampstand or similar device. "This is systematic," Sue said to me after the examination was complete. "These injuries tell the story of months of escalating violence. Some of these injuries are weeks old. Some are older. This is not a single incident. This is a pattern." "I know," I said. "What I need now is documentation. Comprehensive documentation that exists outside of the police investigation process, that can be referenced later if necessary." "Sunadith. I'll prepare a full medical report. Everything will be documented for the record." We left the hospital around noon. Rebecca was physically exhausted, moving slowly and carefully because of the broken ribs and the pain that accompanied any rapid movement. I drove her to a small hotel near the airport, a place where I could arrange for her to have privacy and security while the legal situation played out. For the next week, I became engaged in the most intense legal research I had conducted since my retirement. I reviewed the files that emerged from the investigation into Marcus Chen. The pattern was clear, consistent, and horrifying in its specificity. There were multiple women, multiple allegations, a systematic approach to target vulnerable individuals, and then isolate them through a combination of charm and escalating abuse. Chen had perfected the technique of creating situations where his actions appeared provoked or misunderstood. He had used his financial resources to settle cases and ensure silence. He had carefully positioned himself as a victim of female aggression when convenient, understanding that many people, including, I had to admit, law enforcement, would believe a man's account over a woman's account if the man had the resources and presentation to support that narrative. On the 8th day, a preliminary hearing was held. Chen was charged with assault causing bodily harm, domestic violence, and assault with a weapon. The prosecutor was a woman named Catherine Ruiz, a lawyer in her mid-40s who had built a career on sexual assault and domestic violence cases. She had seen the evidence, reviewed the pattern, and understood what she was dealing with. Chun appeared in court with what I understood was his public persona, composed, expensively dressed, projecting the appearance of a man unjustly accused. His lawyer, a prominent criminal defense attorney named James Morrison, immediately filed motions to suppress evidence and challenge the credibility of the prosecution's case. The preliminary hearing took 2 days. Rebecca testified, and for those hours in the witness box she was a person I had not fully known, articulate, precise, able to describe the progression of violence with a clarity that seemed almost clinical. She had documented dates, locations, and circumstances with the attention to detail of someone who had, at some point, understood that she might need this information as evidence. When Chen's lawyer cross-examined her, his questions were designed to undermine her credibility, to suggest that she had fabricated elements of the story, to imply that she was a spurned woman seeking revenge. Rebecca did not allow herself to be provoked or confused. She remained calm, precise, and unshakable in her testimony. The judge found sufficient grounds to proceed to trial. The case was scheduled for preliminary trial 6 months in the future. During those 6 months, I discovered something about myself that I had not previously known. I discovered that I had spent 42 years in a system that I had thought of as a system of justice, but which I now understood to be, often, a system of competing narratives. The judges did not necessarily determine truth. They determined which narrative was more persuasive, which party had better resources, which story fit more comfortably into the existing frameworks of law and expectation. I began to research the law of domestic violence with a systematicity that bordered on obsession. I reviewed case law, studied the psychological patterns of abusers, read the academic literature on how intimate partner violence operates. And I discovered that my own blindness, my failure to see what was happening to my own daughter, was not an anomaly. It was a systematic failure embedded in the structure of society itself. Abuse hides because it is designed to hide. It isolates the victim because isolation is the mechanism through which control is maintained. And the legal system, despite its best intentions, is often structured in ways that make it easier for the perpetrator to succeed than for the victim to be believed. I began attending sessions of domestic violence advocacy organizations. I sat in rooms with women who had left abusers, with advocates who worked in crisis shelters, with prosecutors who had dedicated their careers to fighting this particular war. And I began to understand that my authority as a retired judge, while useful in maneuvering within official systems, was almost beside the point. What mattered was that I was showing up, that I was listening, that I was willing to position myself as an advocate rather than as an authority. 3 months before the trial, I received a visit from Elena Rostova. She appeared at my office on a Tuesday morning in late August, her appearance indicating that she had rehearsed this encounter many times in her mind before actually executing it. She was a woman in her early 30s, with the bearing of someone who had carefully constructed a professional persona over the ruins of trauma. I worked for Marcus, she said simply. For 5 years I was his personal assistant. He did to me what he did to your daughter. He just did it in Spanish so that fewer people would understand what he was saying. I listened as Elena recounted a narrative parallel to Rebecca's, though with different details and a longer timeline. She had remained in contact with other women who had been through similar experiences. She knew of 5 other women, in addition to those whose cases had become part of the official record. Most of them were terrified of coming forward. Most of them had been threatened, had been told that their immigration status would be questioned, that they would lose custody of children, that their professional reputations would be destroyed. "Why are you telling me this?" I asked. "Because I saw the news," Elena said. "I saw that your daughter was brave enough to fight back. And I realized that if there was ever going to be a moment when we could all speak together, when our collective testimony would matter, this was it. Because you are listening. Because you matter in this world in ways that we don't." There was a bitterness in her last statement that I could not entirely disagree with, though it caused me pain to acknowledge it. "I will help," I said. "I will help in whatever way I can. But I want to be clear about something. Your testimony matters not because I matter, but because what you experienced is real and true and deserves to be heard. The fact that you need someone like me to make that testimony credible is itself a problem that we should be working to solve. But in this moment, in this case, Yes, let us use whatever advantage we have to ensure that your truth is heard. By the time the trial began, I had assembled a team. Elena had agreed to testify. 2 other women whose cases had been settled with non-disclosure agreements had agreed to break those agreements, accepting the financial and legal consequences of doing so in order to provide testimony. The prosecutor, Catherine Ruiz, had prepared an extraordinarily thorough case, with expert testimony on the dynamics of domestic violence, medical testimony about the injuries, and psychological testimony about the manipulative and controlling behavior characteristic of intimate partner abuse. The trial lasted 4 weeks. I attended every day, sitting in the gallery, listening as my daughter's story was told and retold in the specific language of law. I listened as experts explained why victims often delay in reporting, why they sometimes stay with abusers, why they defend themselves in ways that look counterintuitive to people who have never experienced systematic abuse. And I listened as Chen's defense attorney, James Morrison, attempted to construct an alternative narrative, one in which my daughter was unstable, in which her injuries were self-inflicted or exaggerated, in which she was a spurned woman seeking revenge against a man who had begun to distance himself from her. The defense was professionally executed, but it ultimately failed because the evidence was simply too robust. The pattern was too clear. The corroboration from multiple women was too consistent. By the end of the trial, the narrative that the defense had attempted to construct had been thoroughly demolished by the accumulation of evidence and testimony. The jury deliberated for 6 hours. When they returned, the verdict was guilty on all counts. When the word was spoken, guilty, I heard Rebecca let out a breath that she might have been holding for 2 years. Chapter 3: The Aftermath. The sentencing hearing took place 3 weeks later. Marcus Chen was sentenced to 9 years in prison, with the possibility of parole after 6. It was, by the standards of domestic violence cases, a significant sentence. I had seen cases where the perpetrator received probation, or suspended sentences, or other outcomes that suggested that the legal system did not entirely grasp the seriousness of what had been done. But 9 years meant that Rebecca would have time to construct a life that was not in his shadow. 9 years meant that the other women would have time to move forward without the fear of encounter or retribution. 9 years was not justice in the absolute sense. It was not possible to quantify the damage that had been done or to reverse it. But it was acknowledgement that what had happened was serious, was criminal, and had consequences. After the verdict, I spent considerable time reflecting on what this process had taught me about the law, about justice, and about my own role in the system. For 42 years, I had occupied a position of authority that I had understood as authoritative in the service of justice. I had made decisions that affected people's lives. I had issued rulings that I had believed were grounded in law and in proper interpretation of that law. But what I had discovered through the process of seeing my daughter navigate the criminal justice system as a victim rather than as a judge was that the system was not neutral. It was structured in ways that made it easier for certain narratives to prevail over others. It was structured in ways that made it easier for powerful people to avoid accountability. And it was structured in ways that required someone like me, someone with authority, resources, and a position within the system, to intervene in order to ensure that justice occurred. This realization was not comforting. It suggested that justice was not a function of law but of power. And while power could be oriented toward justice, it could just as easily be oriented away from it. 6 months after the trial, I met with Catherine Ruiz, the prosecutor who had built the case against Marcus Chen. We met at a coffee shop near the courthouse, a neutral space where we could talk without the formality of an office environment. "I've been thinking about what you said during this case," Ruiz told me, "about how the legal system can be structured to work against victims rather than for them. I think you're right. But I also think that we can change that. We can change how police respond to domestic violence calls. We can change how prosecutors approach these cases. We can change how judges evaluate the evidence. It takes someone within the system who understands both its power and its limitations." I considered this. It was true that change was possible from within the system, and it was also true that the system by its nature resisted change. Those who benefited from the existing structure did not volunteer to modify it. And those who were harmed by the existing structure often lacked the resources to demand modification. What would you need, I asked Ruiz, to build a consistent program for intervention in domestic violence cases? Something that didn't depend on a retired judge happening to show up. Ruiz leaned back in her chair. Money would help. Training would help. But most of all, I think we need advocates. People who understand that the system is designed to fail victims unless someone intervenes. We need people who are willing to show up for that intervention. And that's what I've become, I realized. After 42 years of believing that justice was something that the law delivered, I've become someone who understands that justice requires advocacy. In the weeks and months that followed, I began to shift the focus of my retirement. I had thought retirement would be a gradual withdrawal from professional engagement, a movement toward leisure and personal pursuits. Instead, I found myself becoming more engaged in the legal system, but in a different capacity. I began to mentor young lawyers interested in domestic violence prosecution. I began to consult with police departments about procedures for responding to domestic violence calls. I began to write and publish opinion pieces in legal journals about the structural failures of the legal system in addressing intimate partner violence. And I began to work with advocacy organizations to ensure that women going through the criminal justice process as victims had support and guidance. Rebecca, in the meantime, was engaged in her own process of healing. The bruises faded, though some of the scars remained. The broken ribs healed. The fractured wrist, which had been improperly healed previously, underwent surgery to reset it correctly. The physical healing was faster than the psychological healing, but both were occurring at the pace of genuine recovery rather than the false speediness of denial. A year after the trial, I drove to a small cottage on Vancouver Island where Rebecca had relocated. She had quit her job and started over in a place where Marcus Chen's name meant nothing, where she could construct an identity that was not defined by her relationship to him, or by her victimization at his hands. The cottage was modest, situated among tall cedar trees and accessed by a gravel road that seemed to intentionally discourage easy passage. Rebecca greeted me at the door with a warmth that had been absent during the trial and the period immediately following it. She had begun to look like herself again. Not like a victim, not like someone trapped in a legal process, but like a person who was engaged in the work of becoming herself again. We sat on the porch in the afternoon light, watching the sun make its descent toward the horizon. The view was of a valley that fell away to the south, with mountains visible in the distance. It was a landscape that seemed designed to suggest possibility and distance from past harm. "How are you?" I asked her. "I'm okay," she said. "I'm not healed. I don't know if I'll ever be entirely healed. But I'm alive and I'm safe, and I'm constructing something that is mine. That feels like enough." I nodded. "I have been reflecting on my years as a judge," I told her. "I spent 42 years believing that I was serving justice, and in some sense I was. But I was also part of a system that often failed people like you. I didn't see that failure because I was at the top of the hierarchy, because the system generally worked in my favor. It took seeing you go through it to understand the reality of what I was part of." "I'm sorry you had to learn that lesson through my trauma," Rebecca said. "I'm not sure there was any other way for me to learn it," I responded. "Sometimes understanding requires direct experience. Sometimes it requires proximity to the consequences of systemic failure. I would have preferred not to have to experience it through you, but having experienced it, I cannot retreat from what I now know." Rebecca reached over and squeezed my hand. "What you did during this process, the advocacy, the intervention, the willingness to push against the system, that mattered. Not because you're a retired judge, though that probably helped, but because you were there. Because you didn't accept the narrative that was being constructed. Because you insisted on truth." I spent that night in a hotel in the small town nearest to Rebecca's cottage. The next morning before I left, I sat on the porch one more time with her, watching the mist rise from the valley floor as the day warmed. "I think I understand now what I was missing in my years as a judge," I said. "I understood the law, but I didn't understand power. I didn't understand that law is a form of power, and that the way we exercise that power can either reinforce harm or interrupt it. I didn't understand that my neutrality was itself a choice to allow existing power structures to continue operating as they were." Rebecca was quiet for a moment. You can't undo the past, she said. But you can do things differently going forward. That's all any of us can do. Driving back to Vancouver, I thought about the trajectory of my professional life. I had spent 42 years in the law, believing that I was serving justice. And in many ways I had been. But I had also been part of a system that perpetuated certain kinds of harm even as it prevented other kinds of harm. I had been blind to the structural failures because the structure had generally served me and people like me well. Now, at an age when many people were winding down, I was finding myself engaged more intensely than I had been in years. I was consulting with police departments about protocols. I was mentoring young prosecutors. I was writing and speaking about systemic reform. And I was learning that advocacy, the willingness to push against systems that are not serving justice, was perhaps more important than any number of judicial decisions I had ever issued. Chapter 4. The Reckoning continues. The public attention that surrounded Marcus Chen's trial had an unexpected consequence. Within weeks of the verdict, other women began coming forward. Some had prior connections to the legal case, having been approached by prosecutors about potential testimony. Others simply saw the news coverage and recognized the pattern of behavior described, realizing that they too had experienced versions of what Rebecca had endured. By the 6-month mark after the trial, there were 9 women in total who had come forward. Not all of their cases would result in criminal prosecution. Some had occurred too long ago for the statute of limitations to apply. Some involved jurisdictions in other provinces or countries where coordination would be complicated. But each of them had experienced the systematic pattern of control, escalation, and abuse that had characterized Marcus Chen's behavior. I began to meet with these women, initially as a mentor and advocate, later as someone helping to coordinate their collective testimony should it be needed in future legal proceedings. What emerged from these conversations was a picture of someone who had operated with chilling system effectiveness. Chen had targeted women in specific ways, women with limited social support networks, women who were financially dependent on him or hoped to become so, women who were unlikely to be believed if they came forward. He had used the same techniques with each of them. Early on, he would idealize them, suggest that they were special, that he had never felt this way before. Then gradually he would begin to introduce criticism about their appearance, their work, their relationships with friends and family. He would isolate them from support networks. He would create situations where they were financially dependent on him. And then, when they were sufficiently isolated and dependent, he would introduce physical violence. Each woman had attempted to leave at some point. Each woman had encountered obstacles, either internal obstacles based on manipulation and trauma bonding, or external obstacles based on his resources and ability to make consequences happen. Some had tried to contact police. Some had tried to contact lawyers. Most had been discouraged by the apparent impossibility of the situation, and had eventually either accepted the relationship or found a way to escape it without legal intervention. Listening to these stories, I began to understand that Marcus Chen was not an anomaly. He was, in many ways, a particularly skilled practitioner of a craft that was far more common than most people understood. The techniques he used, the idealization, the isolation, the gaslighting, the physical and psychological abuse, these were the systematic techniques of intimate partner violence. What distinguished Chen from some other perpetrators was his level of sophistication, his financial resources, and his ability to manage his public reputation while conducting a completely different behavior in private. I began to work with researchers who studied patterns of domestic violence, providing them with anonymized case information that could contribute to their understanding of how these dynamics operated. I began to work with advocacy organizations to develop better protocols for identifying and intervening in abusive situations. And I began to develop a particular conviction that the legal system, as it currently operated, was fundamentally inadequate to address the problem. The issue was not that the law didn't recognize domestic violence as a crime. It did. The issue was that the mechanisms through which the law was supposed to protect people were based on a model that didn't align with the reality of how abuse operated. The law assumed that victims would come forward, that they would have coherent narratives to present, that they would be willing to undergo the public exposure and questioning that came with legal proceedings. But abuse fundamentally works to prevent all of these things. An abuser uses threats, isolation, and psychological manipulation to prevent a victim from being able to access the legal system. When a victim does manage to come forward, they have often been subjected to so much gaslighting and psychological damage that their testimony is confused or contradictory. And the public nature of legal proceedings, combined with the right of the defendant to cross-examine the victim, often recreates the dynamics of abuse within the courtroom itself. I began to work with prosecutors and judges on developing better practices. I advocated for: first, specialized training for police officers responding to domestic violence calls, with emphasis on the dynamics of abuse, rather than simply determining who was the primary aggressor. Second, specialized courts for domestic violence cases, staffed by judges with training in trauma-informed practice, designed to move cases through the system more quickly and with greater sensitivity to the particular needs of victims. Third, improved victim advocacy services, to ensure that victims were informed about their rights and options at every stage of the legal process. Fourth, reforms to the rules of evidence regarding prior bad acts by defendants, to make it easier for prosecutors to establish patterns of abuse rather than treating each incident in isolation. Fifth, mandatory arrest policies in cases where there was probable cause that domestic violence had occurred, removing the discretion of responding officers. Some of these reforms were easier to implement than others. The specialized courts required buy-in from multiple levels of the judiciary and substantial funding. The reforms to rules of evidence required changes to provincial law. But each small change, each small improvement in how the system responded to domestic violence, represented a step toward a more just outcome. Over the course of the second year after Marcus Chen's conviction, I was invited to speak to police departments, prosecutors' associations, and judicial conferences about the lessons learned from Rebecca's case and the cases of the other women. In each of these venues, I found myself delivering a message that was sometimes received with resistance and sometimes received with enthusiasm. The message was simple: the legal system, as currently constituted, is inadequate to address intimate partner violence because it is designed around assumptions that do not match the reality of how abuse operates. If we want to improve our response to domestic violence, we need to make fundamental changes to the way we think about this problem and the way we structure our legal response to it. There was also a personal message, one that I did not deliver in formal settings but that I lived out in my work. I was wrong. I spent 42 years as a judge believing that I understood how the legal system worked, and that my role in it was appropriate and just. I was wrong about many things. I was blind to structural failures that harmed people. I was complicit in a system that sometimes failed victims. I was willing to accept the neutrality of law as an excuse for not engaging more actively in advocacy for change. It took seeing my own daughter go through the system as a victim to force me to confront these failures. I wish I had understood these things without that personal experience. But having had that experience, I cannot retreat from what I now know, and I cannot avoid the responsibility to use whatever platform and privilege I have to push for change. By the time 3 years had passed since that 3:47 a.m. phone call, I had transitioned into something that was no longer quite retirement and not quite active practice. I was consulting with various organizations, writing, speaking, and working on behalf of women navigating the criminal justice system. I had created a small foundation focused on funding advocacy and research related to intimate partner violence. And I was mentoring a cohort of young lawyers who were interested in dedicating their careers to prosecution of domestic violence cases. Rebecca had continued to heal. She had started a new relationship with a man who was genuinely kind, who did not need to use violence or control to feel secure in himself. She had returned to university to pursue a degree in social work, with the intention of eventually working with domestic violence survivors. The scars on her body had faded to faint lines. The scars on her psyche were still there, but they were no longer open wounds. She was, in the truest sense, a survivor. One afternoon in the spring of that third year, Rebecca and I sat on the porch of her cottage. She had purchased it by then, solidifying her commitment to staying in that place of recovery and restoration. We watched the light change as the day moved toward evening, And she asked me a question that I had been asking myself repeatedly since the trial concluded. "Do you think it was worth it?" she asked. "All of this, the legal process, the trial, seeing him convicted and imprisoned? Do you think it made a difference?" I considered the question carefully. "Marcus Chun is in prison," I said. "He cannot harm you or the other women right now. That matters. Your testimony, and the testimony of the other women, has contributed to a growing body of evidence that will help prosecutors and judges understand the dynamics of domestic violence more clearly. That matters. My own transition from judge to advocate, my work with various organizations to improve the system, that began because of what we went through together. That may help future victims of abuse. That matters. But," I continued, "I am also aware that Marcus Chun will be released eventually. There are other perpetrators out there committing the same kinds of abuse and facing no consequences. The legal system remains, in many fundamental ways, inadequate to address intimate partner violence. Justice in the absolute sense has not been achieved, and may not be possible." "So was it worth it?" Rebecca asked again, pressing for a clearer answer. "Yes," I said finally. "It was worth it. Not because it was easy and not because it solved the problem, but because it was true. What happened to you was real. Your experience was not a personal failing or a private tragedy. It was a manifestation of a systematic problem that extends far beyond you and far beyond Marcus Chun. By bringing it into the legal system, by insisting that it be treated seriously, by refusing to accept the first narrative that was constructed, we created a moment of accountability. That accountability is limited, but it is real. And it matters." Rebecca nodded, seeming satisfied with this answer, or at least accepting of it as the most honest answer I could provide. Chapter 5: The Lesson. Looking back on the 5 years that had passed since that phone call in the middle of the night, I am struck by how profoundly my understanding of justice has shifted. As a judge, I believed that justice was something that came from above, from the law, from precedent, from careful interpretation of legal texts and procedures. I believed that my role was to remain neutral, to avoid advocacy, to allow the system to function as it was designed to function. But neutrality, I now understand, is not a virtue. Neutrality in the face of systematic injustice is itself a form of complicity. And law, while important, is not the same thing as justice. Law is a structure, a framework through which power is exercised. Justice is the question of whether that power is being exercised in a way that respects the dignity and safety of human beings. The reckoning that I have undergone has not been a reckoning with the law, but a reckoning with myself, with my own blindness, with my own willingness to believe that my position within the system meant that the system was functioning as intended, with my own failure to see what was happening to my own daughter because I was not paying attention, because I was not sufficiently attentive to the signs of abuse, because I was too confident in my understanding of how the world worked. This reckoning continues. I do not expect it to be complete. I do not expect that I will ever fully understand all of the ways in which I was complicit in systemic injustice during my years as a judge. But I am committed to the process of continuing to learn, continuing to listen, and continuing to use whatever privilege and position I have to advocate for change. The rain that fell on Vancouver the night of Rebecca's call has long since drained away. The seasons have cycled multiple times. The scars on Rebecca's body have faded. The emotional wounds are healing, slowly, with occasional setbacks and moments of difficult remembrance. But the fundamental reality that was revealed through that experience remains true. Justice does not automatically come from the law. It comes from people, from witnesses who are willing to testify, from advocates who are willing to push against systematic failures, from victims who are willing to be brave enough to speak their truth even when the system is structured to silence them. And it comes from people in positions of power who are willing to acknowledge their complicity in systemic injustice, and who are willing to work toward change.